Affidavit of obligation commercial lien. This is a verified plain statement of fact. Maxims. 1. A maxim is so called because its dignity is chiefest, and its authority most certain, and because universally approved of all. 2. All men and women know that the foundation of law and commerce exists in the telling of the truth, the whole truth, and nothing but the truth. 3. Truth as a valid statement of reality is sovereign in commerce. 4. An unrebutted affidavit stands as truth in commerce. 5. An unrebutted affidavit is acted upon as the judgment in commerce. 6. Guaranteed, all men shall have a remedy by the due course of law. If a remedy does not exist, or if the existing remedy has been subverted, then one may create a remedy for themselves and endow it with credibility by expressing it in their affidavit. Ignorance of the law might be an excuse, but it is not a valid reason for the commission of a crime when the law is easily and readily available to anyone making a reasonable effort to study the law. 7. All corporate government is based upon commercial affidavits, commercial contracts, commercial liens, and commercial distresses. Hence, governments cannot exercise the power to expunge commercial processes. Notice to agent is notice to principal. Notice to principal is notice to agent. 8. The legitimate political power of a corporate entity is absolutely dependent upon its possession of commercial bonds against public hazard, because no bond means no responsibility, means no power of official signature, means no real corporate political power, means no privilege to operate statutes as the corporate vehicle. 9. The corporate legal power is secondary to commercial guarantors. Case law is not a responsible substitute for a bond. 10. Municipal corporations, which include cities, counties, states, and national governments, have no commercial reality without bonding of the entity, its vehicle, statutes, and its effects, the execution of its rulings. 11. Except for a jury, it is also a fatal offense for any person, even a judge, to impair or to expunge, without a counter affidavit, any affidavit or any commercial process based upon an affidavit. 12. Judicial non-jury commercial judgments and orders originate from a limited liability entity called a municipal corporation, hence must be reinforced by a commercial affidavit and a commercial liability bond. 13. Governments cannot make unbonded rulings or statutes which control commerce, free enterprise citizens, or sole proprietorships without suspending commerce by a general declaration of martial law. 14. It is tax fraud to use courts to settle a dispute/controversy which could be settled peacefully outside of or without the court. 15. An official, officer of the court, policeman, etc., must demonstrate that he or she is individually bonded in order to use a summary process. 16. An official who impairs, debauches, voids or abridges an obligation of contract or the effect of a commercial lien without proper cause, becomes a lien debtor and his/her property becomes forfeited as the pledge to secure the lien. Pound breach, breach of impoundment, and rescue is a felony. 17. It is against the law for a judge to summarily remove, dismiss, dissolve or diminish a commercial lien. Only the lien claimant or a jury can dissolve a commercial lien. 18. He who is silent appears to consent. 19. Consent makes the law. A contract is a law between the parties, which can acquire force only by consent. 20. Consent makes the law. The terms of a contract, lawful in its purpose, constitute the law as between the parties. 21. To him consenting no injury is done. 22. He who consents cannot receive an injury. 23. The agreement of the parties makes the law of the contract. 24. The contract makes the law. 25. Agreements give the law to the contract. 26. The agreement of the parties overcomes or prevails against the law. 27. It is immaterial whether a man gives his assent by words or by acts and deeds. 28. Ignorance of facts excuses, ignorance of law does not excuse. 29. In law, None is credited unless he is sworn. All facts must, when established by witnesses, be under oath or affirmation. 30. A presumption will stand good until the contrary is proved. 31. All things are presumed to be lawfully done and duly performed until the contrary is proved. 32. Notice to agent is notice to principal. Notice to principal is notice to agent. Public hazard bonding of corporate agents. All officials are required by federal, state, and municipal law to provide the name, address and telephone number of their public hazard and malpractice bonding company and the policy number of the bond and, if required, a copy of the policy describing the bonding coverage of their specific job performance. Failure to provide this information constitutes corporate and limited liability insurance fraud, 15 U.S.C., and is prima facie evidence and grounds to impose a lien upon the official personally to secure their public oath and service of office.
All right. Hope I'm coming in loud and clear. Recording has already started. Class is definitely in session. I'm going to address a lot of issues from arbitration all the way into equipment leasing as an option for you guys that are newly founded or been in the game for a while, compliance officers / notaries looking for an additional way to generate revenue. What you just heard was the affidavit of obligation that I read in most of the proceedings when I do arbitration, and I was in quite a few of them earlier today. Kind of, when I'm, these are exciting times to be alive. The more I do arbitration, the more I realize just how much people really need it, but yet it's really misunderstood by the most because they have this preconceived notion that they think they know what they're doing. They think they know what's going on with the court. The lawyer told them something. I heard through the grapevine. My pastor said this. All of these things have no place in the courtroom because the courtroom isn't what you think it is. It is a bank. The real court is upstairs with the clerk of court. That is the real court. This is where your battle is with the clerk of court. But because you are showing up thinking it's your first appearance in a public tribunal when it's your first appeal, and you're making all these responses, listen, if you listen to this arbitration, if you listen to your arbitration and listen to the instructions that were just read, if you read the affidavit of obligation, you will learn that the entire process is in those maxims. For example, if the person who has said they're foreclosing on your property, or you owe money on a repossession of a car, or whatever the case may be commercially, the person who's doing the accusing, the burden of proof is not on the person who's being accused. The burden of proof is on the person who is doing the accusing. Now, in order for them to even make any type of claim, they first must be bonded and insured. Now, here's where 99% of the listeners start hearing crickets. They'll hear me say they have to be bonded and insured, but they don't ask the question, okay, bonded and insured, why they got to be bonded and insured, Mr. Bay? Because all of those maxims that I just read is how that person who is accusing you have a way to straighten out their books. But if you're in court and they're saying you did something, and when you come to answer that court and you don't ask them to put their public hazard bond on the record, then whatever's going to happen to you usually is what's going to happen. And it's not because they don't like the color of your skin. It's not because they're racist. There's only one race, it's the human race. It's business. Ain't personal. Never was. Never will be. And my mama told me, my uncle told me, my uncle taught me how to play spade. And he said a blind man got no business at the card table. So if you don't know what you're doing in commerce, but you start making all these accusations, and see, the problem with most people is They want to be a trustee and a creditor when it's convenient. When they get too scary and they got to do stuff, now they want to be the beneficiary. And this ain't for you. If you don't understand what you contracted into, and you contract either by paper, or by your tongue, if you don't understand what you have done, there's a part of those maxims that talks about consent. He who has consented can't be injured. If they say they're going to whack you in the face and you consent to them whacking you in the face, and then you start talking all crazy and they smack you in the face, you can't go raising your hand and screaming and go tell it on the mountain that they did something to you. Now, you will, because we're emotional like that, but that has no place in the room of court because you consented. So all they have to do is know that all they got to get you to do is what? Consent. By words or by actions. Silence is a form of acceptance. Oh, they sent me the bill. I'm just going to not respond. Okay. Your remedy is in the fact that you have to literally ask them for their bond. And when they don't, now that's what gives you the ability to put a UCC on them, a commercial lien, because they haven't provided you the bonding information. Now, when they haven't provided you the bonding information, you force them into involuntary servitude. Now the rabbit got the gun. And every Bugs Bunny cartoon I watched, it was never no fun when Bugs Bunny got the gun. So understand, in their ability to try to trick you, lie to you, because tricking, lying, and all that stuff, which is immoral, isn't illegal. Perjury is what's illegal. And in your commercial contracts, a lot of folks have done a lot of stuff commercially, being emotionally correct, but commercially wrong. So when we come along and do arbitration, I cannot make an unbonded ruling. So the bond that I'm speaking upon, issuing awards, is a bond that I've stood on since 2010. It's the same bond that I used to bury my stepfather. It was the same bond that I used that ushered me into this process. It's the same bond that Teresa Tucker, who was a clerk of the court in Bullock County, who decided to send her family on vacation, she's now doing prison time. It's the same bond, tried, true, and tested. So when I use this bond, it's not that I'm saying I don't trust you guys. It's just I have to do things a certain type way because I know where I came from to get to where I am. And I don't expect everybody to have that same fight. See, I fought for my life with this UCC. A lot of you folks think you got options if you don't learn this stuff. You know, I don't get it, I can just go do something else. I didn't have that option. There wasn't anything else. It was this or die. And I chose to live. And I know that freedom has to be something you got to be willing to fight for and die for if you truly want to be free. Even in Scripture, it says the word will make you free. But you got to put in the work. And that's the problem. When it gets to become a fight, most don't want to fight. But we do arbitration, so the battle is already won. See, in their arrogance to draw you into an argument, they're going to have to trample over them being liable, and they're liable because they got a bond and insurance. Instead, they arguing, tongue wrestling with you, threatening your credit and this, that, and the other. That's their violation. They have the insurance in place so that if something happens with the debtor, they have a way to be made whole. But instead, they double and triple dip. See all that fiat you gave them? They didn't even report it to the IRS. It was a payment. They called it a gift. And that should be the very first thing that you start talking about. But again, most individuals don't talk that way. They ain't been trained that way. I don't know. I just heard what my pastor, what the lawyer, and all these other people who do all the talking and you do all the time, you lose all your stuff. Doesn't it seem like if you hire a lawyer and you get damaged, he should share in the damage too? You ain't ever thought about that? I ain't saying, I'm not saying that ain't the actual case. I'm simply saying if you ain't thought about things that way, then you might need to start thinking that way. See, in the aspect of commerce, there are things that are in rotation, in circulation, in implementation. And 90% of most people every day, they go do a whole bunch of contracting and they don't read. And even if when they do read, they don't comprehend what they read. And then when it don't go right, it's everybody else's fault. And the creditor has really the major advantage because all he got to show, whether he got it by hook or crook, if he can show that you consented to all that stuff, then usually the court rules in his favor. This is why statistically, creditors when they go to court to get paid. And every time a debtor goes to court and he's accused of something and they have to explain and argue, they lose. I want to tell you how this blows my mind. People believe when they're in a criminal case that if they plead, they won the case. And I don't run away from these people. I just don't turn my back on them. I walk away slowly. I mean, that's what they believe. Oh, I got a great lawyer. Yeah, what happened? Man, they was going to give me life. They gave me 80 years. He's fired. Okay, if you say so. Then when I have to do their paperwork, and I have to say, well, don't get mad. Just listen to me. Now, when you were sentenced, I'm pretty sure the judge asked you some questions. Yeah, that cracker asked me some questions, and he did this, and he did. Okay. All right, let me humor me this, Batman. All right, when he asked you these questions, did he ask you, was you promised anything? And then they get quiet. I said, what did you say when he said, was you promised anything? Well, how did you respond? Mr. Bay, I I didn't say anything. My lawyer, I looked at my lawyer. My lawyer said, no, he got this. Don't say nothing. Now, when did you first get this plea? Did you get the plea before you went into court or you got it during court? Well, he told me before we go into court that he got me a deal. Ain't that a promise? Now, don't get mad, but if the judge asked you, why on earth, because this is what he really said, you didn't comprehend it, went over your head. He literally asked you, what in the hell would compel an innocent person to testify against the goddamn self? Were you promised anything? And you said no. Why are you under the influence of alcohol or medication, or do you have schizophrenia in your family? Are you mentally, they want to know, are you in your right mind? Because what would compel an innocent person to testify against themselves? And then when you say all this other stuff that everybody else told you to say, and they say, okay. And when they give you all those years and all the stuff, and you come out with your head hung low, and you start saying, oh, man, the court is this. The people don't like me. It's racist. No, your good dumb ass just can't fucking read. Pardon my language, and I got to say it that way, but that's exactly what it is. And when you was reading, you didn't comprehend. And because you want to go into court and argue, this is why you got the result that you got. So when I do arbitration, I have to put all that emotion and jazz and who shot John aside, because the only thing I care about is who was damaged, for how much, and who need to be paid. All that other stuff, which is great for paperwork and this, that, and the other, has no room in the solution. See, everybody who accused you of something, they all bonded and insured. And when I do arbitration, I circle back to the fact that, well, since everybody was bonded and insured, let's take a portion out of this bond and make everybody whole. But first off, who was damaged? When I look at the paperwork, it says the state of Florida. It says the state of Georgia. It says the state of Colorado. How on the earth can a state be damaged? Can the state take the stand and tell me how it was damaged? But see, I don't want to be a smart aleck either, because I ain't trying to be, I'm there to get paid. I'm trying to get you paid. I'm trying to get the estate paid. So we have to bring it down to the part that nobody wants to do, which is accounting. That's why it's about the insurance. That person has to have a public hazard bond, and you have a right to ask them, what is their public hazard bonding company? What's their name? What's their address? What's their policy number? But when you don't do that, you just shot yourself in the foot. This is why 90% of whatever is going to be used to get you into the house, the car, get your stuff liquidated, you're going to have to do arbitration, because you sew up your own butt with all the stuff you done did before we got there. You're in your own way. And only a notary, in my opinion, has the best ability to do these processes. See, I can't do a process for myself, but I can do processes for other people. But if the people that I'm trying to do the process for is in dishonor, they don't understand, they incompetent, now I got to go to a notary. Because a notary ain't going to get nothing out of doing this for that person. They're just going to administer justice. They're an uninterested third party. Now I got to go to them. Here's the merits of the case. And they make a determination off of fact. I started this class this way because I want you to understand the fundamentals of arbitration. I want you to understand that you're going to have to be the change you want to see. I start this class out this way because you need to understand that it ain't up to nobody else to save you. You're going to have to save yourself, but you're going to have to save yourself by doing something that you probably never done before, which is going to do a whole lot of reading and comprehending and staying up a lot of late nights, maybe not doing so much Netflix and all this other stuff. I know it's the summertime and you want to do this, that, and the other, but see, we're the only people, broke people are the only people that take vacations from being broke. Wealthy people don't take vacations away from being wealthy. Matter of fact, what you call a vacation, they call a site visit. They just happen to be meeting in the Bahamas. They happen to be meeting in Hawaii. That's where their family offices are meeting at, conducting business. You call it a vacation, they call it a site visit. It's a total different allegory. People who are broke will wear $200 shoes, will wear $1,000 purses and all this other stuff. Wealthy people don't do that. See, the whole allegory of wealth, financial literacy is, in my opinion, dead in the United States. And it's been dead for a long time. And we don't make it any better because we don't put no emphasis on being financially literate. We think it's cool to not know stuff. We think it's just really cool that you don't know nothing about how the banks work. We don't know nothing about how the economy works. We don't know nothing about Uniform Commercial Code, and these are the same things that you'll be on the phone with, hooting, hollering, screaming, and crying about that you need help with. And 9 times out of 10, the stuff you need help with is stuff you signed up for and consented to. It's just, it ain't working out. I ain't making the money. I didn't have this. Life. But let me tell you something about commerce. They have trained you so well that you believe that you can somehow save your money and become wealthy. There are people that are in this class that may have believed up until this point that I can just put my money away and I can save, and one day I'll be wealthy. That's not how wealth works. First off, there's a such thing as good debt and bad debt. Does anybody in this class have any idea what I mean by good debt? If you do, press 9-4 on your keypad. I will bring you forth for the class, and you can give your interpretation of what you think good debt is. That's how we're gonna do today's class. Because I've been going over these audios. I'm redoing the transcripts. And I get too much feedback when I bring everybody on and let them. So I am going to assume that if you got a question, you're going to press 9-4 on that keypad, and I'm going to bring you on. That way I won't get all this extra feedback and this, that, and the other. So, who in the class has an idea of or an example of good debt? What is good debt? Anybody have an idea what good debt is? Okay, let's see here. I think we got, I think that's Brother Lamont right there. Brother Lamont, can you hear me?
Hey,
What's good?
Mr. Bay, how you
All
doing?
right, all right. All right, all right.
So, in my opinion or my understanding, I'm thinking good debt is good debt that you can that someone would buy.
Beautiful. I like that answer. Debt that somebody else would buy. That's key. I like that response. That's good because see, the wealthy, they have debt that has equity. It's like debt that performs. It's like good debt is debt that you're in, but it's performing. See, bad debt is what you're trying to get out of. The wealthy is never trying to get out of debt. That's another misnomer. People believe, how you know the spell Leviathan is working on you is when you wake up like, man, I'll be glad when I get out of debt. They got you. You'll never be wealthy thinking that way.
Isn't that part of like and I'm recollecting a little bit of what I think I read in one of the manuals.
Mm-hmm.
Isn't that like a part of like leverage buyouts and stuff?
Right. Leverage, the whole reason why leverage buyouts work is because you're leveraging debt and equity to absorb assets and control resources. So when you have adopted that practice of I'm trying to get out of debt, and they can see you coming a mile away. You show up with your good credit profile and your business plan and your Brooks Brothers suit and smiles, and first thing that lawyer, if he's smart, gonna ask you, say, okay, we see here on your projections, because here's the deal. Everybody who knows how to play poker, they understand that no matter what version of poker we're playing, somebody's going to determine based upon a preset rule which way the game of poker going to go and how the hand's going to be called. So when you sit at the table, and this is supposed to be an equity deal, they're going to immediately ask you, because see, you're sitting across their table, your books of business, you know where all the bones are buried. At least you're supposed to. They're going to ask you very specific. They could probably ask you about 5 questions, and 6 of them, or 5 of them, or 3 of them out of the 5, they're all going to be about equity. And this is a competency test. They're going to ask you, well, we see here on your income statement that you make this amount of money. And then we look at the balance sheet on these expenses, we see that you're spending more than 10% of your disposable income. Now, that's an opportunity for you to wow them with your ability to leverage debt. But if you immediately go into what had happened was, and I need to get with my CPA and he can explain it better, or if you totally avoid the opportunity to demonstrate that you're leveraging debt to offset that overage over 10%, you just failed the first test. The second test gonna come when you think you got them over a barrel because everybody's agreeing, they're smiling. Then they're gonna say something like, "Okay." Now they're gonna pull up your assets, and you got all this stuff listed as assets. Now, if it's a lawyer versus a CPA won't say jack because we're taught to ignore stuff. A lawyer gonna look you dead in the face and be like, "Okay, well, what other assets are you using to mitigate risk?" That's your opportunity to say, "Well, hey, I got this life insurance policy, but if you talk about everything and what had happened was, and we got this great idea that nobody ain't ever done before, I ain't never done it either, all that sound good." But you just felt the second part of the test. Now, here's what they know. This thing sounds great, and they know they can get it insured. You know why? Because your dumb ass didn't. Now, they going to see, do you know what you got? And they literally going to hang out the carrot. Listen to this. "Oh, man, I don't think this deal's going to work. This, that, and the other, blah, 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 woo, woo, woo. Our lenders will get back with you. They'll tell you the reason why." Now, again, at that point, anybody who denies you funding have to put it in writing why they didn't provide the funding. Every deal that I've sat in on that level, and it's amazing, people that don't have that kind of money at stake, at least American Express will write you a letter and say why you didn't get the credit card. But big money deals, they throw it up in the air. And if you seize the opportunity, y'all going to meet at the finish line. But if they throw that thing up in the air and you just walk away and leave it, that same deal that you didn't get funding, they going to fund. All they going to do is just change management. And when I lived in Georgia, Fulton County, Gwinnett County, I worked with a guy by the name of Tom Plummer, who was a big-time financier all over the United States. Tom Plummer sat in my office for over 6 months. And finally, after he realized I just know a little bit than the average person, he straight up told me, he said, "Look, man, if you can just write this white paper," listen to how he said this to me. "If you write the white paper, and me being the white boy, I just go out there and show it, we can do this all day." I said, "Well, so this whole 6 months, what you were trying to figure out?" He said, "We was doing an investigation. We're trying to see where you getting your intel from. Because we ain't never seen a person of your stature, your color, your age, talking about debt securitization just like you're talking about football scores. And the average person, they're not left-brain thinkers like that. They want to get out of debt. They believe they can save their way to freedom." At that moment, I kind of had to make a decision. I'll tell you about that later. But anyway, understanding that your deals are funded by the insurance that it has or will have gives you the ability to reinsure it just as fast, almost simultaneously. And these things becomes predicating proponents for leveraging in that regard. So good debt, like Brother Lamont said, is debt that you can sell. somebody else. And I think if you've been in this course of study for at least 3 months, 6 months, a year, you probably got some debt that, with certain things on an affidavit, can really become good debt to somebody on their book. What might that debt need to look like though? If it needs to be sold. Does anybody have any idea on what it might need to look like? And again, if go ahead, Lamont, you're still unmuted, so you can definitely
Yeah,
respond.
I was sitting here thinking about it myself. Uh, so I'm thinking that if a company is in debt,
Mm-hmm.
but they are, again, I'm just trying to go off the top of what I think I
Yeah,
read
yeah,
here. If a company is in debt, but that company is bringing in, uh, or they are bringing in revenue. The
right,
company is generating revenue,
right,
and I'm thinking that a company could, maybe to get money, to raise money, could
right,
get a set of investors to say, hey, look,
right,
we'll give you some money to pay off your debt,
right,
to get whatever for a percentage down the line of the revenue generated.
right. Or a line of credit, like the bankability and markability. A company. How many of you guys have ever heard me say in one of my classes, or any of the classes you've heard me talk about, where a lot of entities, they have a constitutionally protected right to contract, and they also have a right to borrow, and they have a right to lend. This is why you got a right to borrow and a right to lend. If the only reason why you're uninsurable is because of the lack of credit, then debt can now be leveraged to acquire insurance. Legal entities have the right to borrow and lend because borrowing and lending is the backbone of business. I know people personally think it's my backbone. I want to borrow and lend. You would have thought about it after the fact. Borrowing and lending is for businesses. So if you're a business, you have a right to borrow and lend. And if you've just been doing a whole bunch of borrowing and no lending, maybe that might be the problem. Mr. Bay, what if I ain't never borrowed? Well, if you never borrowed in business, that means the glass is half full. Well, Mr. Bay, what if I borrowed in business and I blew the money? Yeah, that's what happened to a lot of people. But all is not lost because they got programs. Look, speaking to a fiduciary today, they are a member of SBA, and I've been telling everybody they got programs where if you ain't ever had any funding with SBA, if you was denied ERC, if you was denied PPP, and you have an EIN and you have a legitimate business and you have the capacity to operate this business. Now, you can't just say, I'm finna go be an astronaut and go to the moon, and you don't have nothing but a GED. Come on now. You got to at least be in a capacity where if somebody was to bestow capital on you, you can perform. Because what does insurance cover? Performance. The quickest way to get all of us is in trouble is to put all this stuff together and then don't have the skill set to do what you came to do. Give me a business that you don't have to have a college degree to do. Somebody name a business that you don't need a college degree to perform.
Sell hot dogs.
Okay, sell hot dogs. Okay. All right. So if a pack of hot dogs, give me a price. How much does a pack of hot dogs cost these days?
Let's say $1.19 minimum.
Okay, a pack of hot dogs costs $1.19. A pack of hot dogs. And then you got to get buns, and then you got to get ketchup. Well, in order for you to operate successfully, let's say, would you say the hot dog to buy the hot dog and prepare the hot dog? Let's say it costs you $2 a hot dog.
Let's say $5.
Let's say it costs you $5 to get the hot dog. Well, how much you got to sell the hot dog to make a profit? 5 on 1, right?
Yep.
Okay. I ain't say how much of a profit. I'm just saying you got to set up at least 5 on 1.
Right.
So you got to find a way in the marketplace to get these $5 hot dogs for $2. Now, if you can get those $5 hot dogs, because it's equity, for $2, that can be insured. Now you can start your hot dog business, because what? You know how to sell hot dogs, and your idea can be what? Insured, because there's equity there. Now, if you can't start your conversation in business like that, then that's what kind of gets you off in the gutter somewhere. I think I got another question. Let me go back to caller. Last for digit, your number is 1945. I just seen your hand raised. 1945. Can you hear me?
Yes, sir. I can hear you.
All right. I just seen your hand was raised, so I can hear you.
This is Edith. I was going to tell my comrade he was born back in the 20s to get a pack of hot dogs for $1.20.
Say hot dogs a whole lot more than that. Eh?
Boy, the other day in the store, it was like $4.89, well, $4.79, something like that, almost $5 a pack.
Wow.
It's been a minute. so you technically you got to get these $5 and $6 hot dogs for about $2, and you got to have a way to get off of them. But the case in point, if your idea has equity can be insured. Now, this works all the way in everything you do commercially. You're thinking when you get a credit card, you get a loan, that they're waving some fairy dust and it's just coming from the ethers. When in fact, everybody who was born with a birth certificate in this country was given a form of insurance. It's called Social Security Insurance, SSI. So if you got that Social Security number, you got a $6 million insurance policy on you for their benefit. That's why they can lock you up and get $300 a day out every day they hold you, because you're the money. It's like the money in your purse or your wallet. You're the dollar. You're the denomination. Now, some of us are ones, fives, tens, 50s, and hundreds, but nonetheless, we're all paper. In this system, different denominations are spent in different ways, but they're all being spent. And the dollar don't have a say-so on who hand they go to, in what condition they go to. They might not want to go to my wallet. They might not like the color black. They might be prejudiced against blue, but it means nothing when I'm the one that's doing the folding and passing. We're controlling it. So it's not about how you emotionally feel about what's happening. It's about the person or entity that's in the position of control. And those that are in commerce, they are in control. And they have to have something to control, which ultimately comes back to our same conversation. There's only going to be 1% of the population that really understand what we're talking about. So don't be surprised when you ask these people and they look at you like you hit them and stole, they look at you like you from Mars. Don't feel bad, because everybody ain't going to know this stuff. It ain't for everybody to know. It's to a point now, even if you do know it, they don't care. All they care about is everybody else that don't know. If you wake up and learn this stuff and get off the plantation, you save your property, save your estate, good for you. Now, if you go tell your neighbor, now we got a problem. Now, I ain't saying everybody be selfish and save yourself, but I do say we're here to save the savable. The truth need no validation from me, you, or anyone else. The truth is still going to be the truth, whether you do anything with it or not. If you don't file now UCC, you don't do no arbitration, the truth will still be what it was before all of that. And the truth still will be the truth after all of that. Now, I have to tell people this to tether them to truth so they can see their process from beginning to end. I had to lose everything that I thought I knew in order for this information to take hold and I can properly use it in the way that I'm using it right now. Because as long as I clung on to what I thought I had and what I knew, I was going nowhere. I was in my own way. I send paperwork off and I'm expecting them to say, congratulations, you did this right. I've sent in over 300 instruments. And every institution I sent it to, none of them never gave it back. They pretended like they didn't get it. But they never gave it back. I'm going to show you something. Now, I'm not going to go into their whole file because they're under a non-disclosure. And I'm under a non-disclosure. But for illustration purposes, because some of you guys need to see this to really get what you're doing in arbitration and how you're going to work this stuff. Mr. Bay, how I'm going to do this? They didn't send me this. And let me just hold your horses. Those you can see my screen, you should be looking at a form. How many of you guys can see this form on the screen here?
I can see it.
All right. Now, I've had students say, Mr. Bay, I ain't never seen a UCC 5 before. Well, you're staring at one now. This is a UCC 5. What does it say it's called? What does it say it's called on this form?
Information statement.
Information statement. It's a caution. This is not an amendment. So this form is to be used for correcting. Now, they're going to ask you about a UCC number, the initial financing statement file number. They're going to ask you the record information to which this information statement relates to. They're going to say, check one of these 3 boxes to indicate the claim made by this information statement. Record is inaccurate. Enter item 3, the basis of the belief by the debtor of record identified in the item 5 that the record identified in item 1 is inaccurate, and indicate the manner in which the person believes the record should be amended to cure the inaccuracy. This is not an amendment. You use this form to correct. The second box, record was wrongfully filed. (2C), record filed by person not entitled to do so. Riddle me this, Batman. If the person tells
Dr.
you,
Bay,
mm-hmm.
Yes. I'm in Victory, but I can't find you.
Okay, if you go inside of, if you look at the actual link that I sent to you, there's going to be a link where you can actually see my screen. Like if you're just calling into the call-in number, you're just listening to me. There's a link that, like, if you got it on your phone. Matter of fact, if you're inside Bitrix and you go to where I sent the link out by the event tab, it's going to have a link in there that you can toggle on to come to a screen where you can see my shared screen.
Event. Okay.
If you don't see it, look at your phone and go onto your phone because I texted to the phone as well, and you will see inside the link. It should say press. It's gonna be a link in there that you press, and it'll take you to this free conference call app, and you'll be able to see what I'm sharing. If you can't see it, don't fret, because I am recording it, and I'll make it available where you can see it if you can't see it right now.
Okay.
But you should be able to use that link to follow it. But on 2C,
okay,
it says the record filed by person not entitled to do so. So riddle me this: if you're trying to go from a debtor to a creditor, number one, record is inaccurate. Number two, record was wrongfully filed. 2C, record filed by wrong person not entitled to do so. If you're a debtor trying to become a creditor, which one of these you probably will use? Now, I'm not saying one is right and the other is wrong. I just want to see where your head is at. You're trying to go from being a debtor that they say you are to a creditor, because it's not what you say, it's what you do that determines who you are. Which one of these options you'll check off here?
Read those options again, please.
Record is inaccurate. That's number one. Record was wrongfully filed. That's number two. Number three is record filed by person not entitled to do so. And you're trying to go from being a debtor to a creditor. Which one of these will you check so you can change and correct the record? 1, 2, or 3?
The record is in. I checked number 2. It's incorrect.
Right. It was wrongfully filed.
Right. It was incorrect.
Right. Okay. Or if you're saying incorrect, you would say that's number 1. Record is inaccurate. Right.
Yes.
That's the one you would rather use. Okay. And I'm just want you to think about that, because when you use this form, that's what you're using it for, to correct the status. How you going to call yourself a secured party creditor when you haven't changed the status in the system to be a creditor? Now let's reverse engineer this. Let's say they're accusing you of all this other stuff. What kind of UCC are you looking for then? A UCC 5 so they can be on top. But if you don't see no UCC 1, no UCC 5, no 3, or no UCC, are they in compliance or out of compliance?
Out of compliance.
All right. Now, somebody in class, I told everybody from here on out when you come to class to go ahead and set up your chat GPT. And I want you to do so because I want you to look up a UCC for me. The UCC I want you to look up is the one I got highlighted, called UCC 9-509. That's the UCC I want you to look up. Because, see, I'm going to do it myself. I'm sharing my screen so you're going to see me do it in real time. But it'll help you if you do it yourself, because you're going to need to get practice with doing this chat GPT. Because I'm finna tell you, we're moving out the slow lane into the fast lane. Now I'm going to go ahead and stop my share just so I can get in the right space.
What is UCC 9 dash what?
It should be UCC 9-509.
Refers to a specific section of the UCC standard laws concerning transactions that govern commercial transactions, including the sale of goods, securities transactions, negotiable instruments, the priority of security instruments, and personal property, specifically addressing the concept of control as pertains to certain collateral types, particularly focus on control as a means of protecting the security interests in investment property, deposit accounts, and electronic chattel paper. UCC 9-509, secured party can establish priority over other competing claims by obtaining control of the collateral. Control is achieved through different methods depending on the type of collateral. Investment property control is typically obtained by the secured party after having possession of the investment property or through the control agreement with the intermediary holding the investment property. Deposit accounts. Control over a deposit account is established by the secured party having either exclusive control, that's where only the secured party has the authority to direct action on the account, or control by agreement, where the debtor, secured party, and bank agree to the control arrangement. Electronic chattel paper. Control over electronic chattel paper is typically established by the secured party having control over the system of record that maintains the electronic chattel paper. By obtaining control over the collateral, the secured party ensures the security interest takes priority over other competing interests or claims. This priority is crucial in determining who has the right to the collateral in the event of default or bankruptcy. It's important to note that the UCC is enacted at the state level, and while UCC 9509 represents a general provision, individual states may have adopted the UCC with slight variations or additional provisions. Therefore, it is advisable to consult the specific UCC provisions in your jurisdiction to seek legal advice to understand the application and interpretation of UCC 9-509 in your particular situation. That's all I got in there.
Oh, and that's beautiful, because literally what it's telling you, it's imperative that you understand why you're doing the UCC 5. Now, be clear. UCC 9-509, and you're deciding the record was filed by a person not entitled to do so, boy, that's a loaded gun. That's a loaded gun, and this is why stockbrokers don't know how to fill out this UCC 5. But if you hand them one, they sure can go get you some money that day. They're never taught how to fill this out. All of us as stockbrokers were all taught how to monetize it, though, because this is how you're able to write letters of credit off of it. Very powerful. And if you got your AI tools, you would, if I were you, I would incorporate most of the stuff I'm dealing with these bill of exchanges under that provision. You don't have to. I'm just saying it probably would make most sense to do so. Based upon what you just read, Brother Lamont, what did you find most intriguing about UCC 9-509?
One of the control aspect showing
control. It shows control. If someone is foreclosing on your property, wouldn't they need to have this UCC in their possession to control the property?
Well, you said what they had to.
I'm gonna say this again slowly.
In their possession,
they are doing the whole song and dance. You ain't paid us our money. We want to put you out. We want to foreclose, and they doing all that jazz. But somebody need to have some paperwork that's got this UCC 9-509 on it, right? Somewhere. Now watch how dangerous this is. If you didn't come to this class and you missed this portion of it, and you're out there tongue wrestling with these people and this, that, and the other, you ain't got to tongue wrestle with them. Ask them to show you the UCC 9-509 that gives them the right to do what they're talking about
doing. UCC 9-509.
509, correct.
Ask them to produce it.
produce the documentation that puts them in compliance with UCC Section 9-509 for your particular state, because you're going to have a UCC 9-509, and then if you're in the state of Florida, you're going to ask what's the equivalent of the Florida Commercial Code that pairs up with UCC. So you got to get this code to know what code applies in your state. So they got to show you both codes.
You asked the court that, or you asked the?
Whoever,
sorry. You asked the court that.
You ask whoever is trying to enforce their Article 9 security interest on your property, because this is This is under Article 9. So you filed a UCC to protect your Article 9 security interest. So they need to have something under Article 9-509 protecting their interests. Now, if you can go show them your UCC 1, your 3, and all the other stuff you're doing, and they can't show you jack, and then you turn around and ask them again, well, just show me the documentation that's in compliance with the state and federal code, and they fail to do so, anything that's done outside of law is to be considered not done. If the contract makes the law, and this is the Uniform Commercial Code that is the law that governs your agreement, and they do something outside of that law, it's to be considered not done.
What if you didn't sign the agreement?
We'll say this again. Consent. If you consented, that means you can't claim injury.
Silence is acquiescence, right?
Right.
If you don't sign something, is that the same thing as
being
silent? No.
Let's be clear. In all contracts that we're talking about on the Uniform Commercial Code, it's got to have offer, consideration, acceptance, and signatures with an S under penalty of perjury. So where is the 4-part lawful legal contract that substantiates your claim?
Right. Got you. I understand.
So if you got a UCC and all that jazz, and you done your 1 and your 3, now you're ready to do your 5, and then after you go under 9-509, now you get to do a letter of credit. How many of you guys ever seen a letter of credit before? Y'all want to see one? Who want to see a letter of credit?
Me.
Okay.
I think we all do.
I do.
Okay. The eyes have it. Okay, we got 2 people at least want to see it. That's all I need. I'm going to go ahead. And if you didn't want to see it, damn it, you're finna look at it. I'm going to show it to you. All right. Let's stop the share. Now, by law, I have to show you what you as a notary is supposed to use to author a letter of credit. And I hope some of you guys will ask certain questions from what I'm showing. Like maybe what you see might spark the right type of question. Now let me show you. Yes, I'm going to pick it. I got it right here. Okay. This is the one that I did for a client with the Treasury. And I'm not showing you your screen. I'm not showing the screen on purpose, guys, to make sure I don't show too much. Can I show them the judgment fund transmittal? Okay. All right. Okay. Just don't show the client's information. Okay. All right. Okay. All right. I'm going to show them the judgment, the data sheet. All right. This is why you need a notary. Because, see, this is what the notary uses. Somebody might ask a question that I'm compelled to answer, then if it comes up, then we'll deal with it. If it never comes up, then I can't deal with it. Here we go. We're going to share the screen. And we're going to go here. How many of you guys can see my screen?
I can.
Okay. What does it say at the top of this form here.
Underboard data sheet.
Who is this from?
Bureau of the Fiscal Service.
How many of you guys know who the Bureau of Fiduciary Fiscal Services? Who know what that bureau is? If you don't and you got Chat GPT, tell me what it is. Because you got to see it. Then if you ask a question, I'm compelled to answer.
So the Bureau of Fiscal Service is a bureau of the U.S. Department of the Treasury. Fiscal Service replaced the Bureau of the Public Debt.
Stop. Say that again.
The Fiscal Service replaced the Bureau of the Public Debt.
Stop. Say it one more time.
The Fiscal Service replaced the Bureau of the Public Debt.
Bureau of the Public Debt. Look that up.
The Bureau of the Public Debt was an agency within the Fiscal Service of the United States Department of the Treasury. The United States Secretary of the Treasury. Let me see if I can get deeper in here. Okay. It was an agency within the Fiscal Service of the United States Department of the Treasury. The United States Secretary of the Treasury, Timothy Geithner, issued a directive. Geithner issued a directive that the Bureau be combined with the Financial Management Service to form the Bureau of Fiscal Service in 2012. Under the authority derived from Article 1, Section 8 of the Constitution, the Bureau of Public Debt was responsible for borrowing the money needed to operate the federal government, and is where donations to reduce the debt were made. It also accounted for the resulting debt, and more recently provides administrative and IT services to federal agencies. Principal operations were conducted in Washington, D.C., at Parkersburg, West Virginia. Additionally, Federal Reserve banks, acting as Treasury's fiscal agents, operate critical systems in support of public debt programs and perform a variety of processing and customer service functions in marketable and saving securities. The Bureau also provides reimbursable administrative and information technology services to other government agencies through the Administrative Resource Center, or ARC. Public debt fulfills its mission through 5 different programs: wholesale security services, government agency investment services, retail security services, summary debt accounting, and franchise services.
Let's stop it right there. If you put all that in one umbrella, that is the court register investment system. That's the CRIS. So what agency governs the CRIS? What bureau?
The Bureau of Fiscal Service.
That used to be called the Bureau of what?
Public Debt.
Okay. Now, when you're a notary, you're supposed to put your judgments on this data sheet.
And send this in to the Bureau of Fiscal Service.
So, this data sheet, enter the principal amount payable, excluding attorney fees, cost, interest, and cite legal authority for that award. For instance, FTC 28, United States Code 2672, or Fifth Amendment, taking each attorney fee payable, if any. Cite legal authority for that award. For instance, equal access to the Justice Act. Enter the cost payable, if any, and cite legal authority for that award, for instance? Read number 6. Can y'all see number 6?
Enter any deduction specified in the judgment or settlement agreement. Hold on.
Keep reading.
Enter any deduction specified in the judgment or settlement agreement or debts to be set off under 31 U.S.C. 3728. Indicate the reasons for the deduction. For instance, FTCA withholding or debt set off pursuant to 31 U.S.C. 3728, and the payee agency's name and ALC. If this otherwise, FS must seek claimant's consent to the set-off and may only withhold from payment an amount sufficient to pay the debt plus the cost of litigation. Litigation will be required to effect the set-off if there is no judgment of debt or if the claimant declines consent to the set-off.
Let me stop you. When you plead guilty and you go to the public tribunal and you never bring up who got insurance and all this other stuff, doesn't that constitute consent to set off? Or decline consent to set off?
Could you say it one more time?
All right. You're supposed to say, show me your public hazard bond, your bonding company, their address, phone number, and policy number so we can make a claim. Failure to do so constitutes a decline to consent to set off. So every time you don't do what you're supposed to do, guess who's filling out these forms?
They are.
The clerk upstairs. Remember, she's just a custodian over the counter. Right. She's just a custodian. Whenever it's not what you say, it's what you do that determines who you are. This is why I'm saying there are, now I can talk freely if y'all ask the right question. There are trustees that go to the court every day and making withdrawals out to Chris. And they use his data sheet to do it. If you go in with a data sheet, you'll get a check. If you don't go in with a data sheet, you're going to get a what? Tax form.
Say it again. If you go in with the data sheet,
right,
you get a credit.
You get a check. Okay. Without the sheet, you get a credit. You get a tax form. Now, for those of you that got your Chat GPT and you got access to this form, because if you ain't got access to the form, if you tell me, I'll send it to you. You need to take.
I don't have access.
I don't have access.
Rush it on.
Right, right. So making that type of request gives you the ability to be in compliance, because once you record it in your journal, this is how you push it out of the Chris.
But
Mm-hmm.
Okay, now my brain is jumping ahead. My thoughts are jumping ahead.
Now this is just. Let me go a little further, because I might answer your question if you see more. This is just a data sheet. Mm-hmm. Now, after you get past the data sheet, what does this say?
Oh, that's a transmittal.
Okay.
So those are the instructions.
Mm-hmm.
Is that right?
Pretty much.
Okay. Oh.
Let's read it. Dear Sir, Madam, I am the authorized representative of the United States in the above captioned matter as described in the enclosed documentations. I certify that all pertinent criteria required by law for approval of this claim has been satisfied. Now, if this is an administrative claim, the settlement was made with the United States in this matter, and any portion of the agreement required to be paid from agency funds will be and have been paid from those funds, If this is a litigative claim, the award made in this enclosed judgment or settlement is payable by the United States, and any portions of the award required to be paid from other parties or sources will be or have been paid from those parties or sources. The United States will not seek further judicial review of this award, and I have attained all approvals necessary for its referral for payment. I believe that this award qualifies for payment pursuant to
31 USC 1304. Now,
and you, go go ahead, go ahead.
okay, so I see the signature right there. It says submitted agency authorized signature, and I see that you said if this is a litigation claim, made in closed judgment or settlement is payable by the United States. Any portions of work will be paid from certain funds. Then it says United States will not seek further or judicial review of this award. And so okay, and this is from the Bureau of the Public Debt, which was now the Bureau of what was it? The Bureau of Public.
Used to be the Bureau of Public Debt. Now it's the Bureau of Fiscal Services.
Fiscal Service, right? And so public debt. This all fall under the HJR 192.
Exactly.
Oh shoot. Okay.
Now this right here is the transmittal letter. Hold on, we ain't got to the good part yet. What does this say?
Ooh, judgment fund voucher for payment. Ooh.
Right.
Wow.
You see this TAS? That's your fast manual. So when you put that symbol in that, they'll know how to route it to you. They tell you what.
Okay, so you need my. Excuse me, sorry. So you gonna need my bank account number?
Yeah,
okay.
gonna need that information. Yes, ma'am.
But shouldn't all of this stuff be routed to a trust, right? It's still it has to fall into a trust account.
When I do arbitration, I try to make sure that you stay in compliance on the current expected credit loss provisions, and I'm giving you everything you need. That if you need to go and make an M2 and M1, you have the ability to do so. Well, I'm always going to tell you. Go ahead.
And not just any trust. Doesn't the trust have to be a foreign grantor's trust?
It depends on your position. Like, everybody's scenario is different. Okay. Like in Edith's case, she's got a very specific thing happening. That's why she was saying, I now need to send you because she's right in that capacity. Because this is going to mean a lot of things to a lot of people differently. But I'm not allowed to just hand you this form. Now, if you got the Tony King documents and you got the Patrick Devine documents, and what is going to happen is they are all referring to the Bureau of what? Public Debt. That got merged by Timothy Geithner to the Bureau of Fiscal. Right. So here's what happens. People who don't do no reading, they're quoting stuff under the Bureau of Public Debt, and it's not called the Bureau of Public Debt anymore. It's called the Bureau of what?
Fiscal Service.
And then they go into court and tongue wrestling. They're emotionally correct, commercially wrong, and then the bracelets come out.
You said the Tony King documents and who else?
Patrick Devine.
Oh.
Because everybody is telling you got to know more than just what I'm telling you. It's not what I'm telling you. It's about what you know. Because what the powers that be going to ask you is, this sounds like some sovereign citizen stuff. Because they demonize the word sovereign citizen. Why? Because true axe murderers and pedophiles was using this stuff to get out of prison. Because it worked.
That was going to be my next question. But I was going, I was
Right,
reluctant enough
right,
to ask that.
right, right,
I got friends and
right,
family members,
right, right,
doing
right.
some time, and I'm looking at this, and based on
Yeah,
saying
it could be
about,
used.
yeah, okay,
You just got to be on the right side,
yeah.
cause they use it all the time.
And is
It's
there
just
is there a statute of limitation on this stuff? Could you go back and, I mean, like, if it was already done, this form filled out
hmm
for a particular case, and you're not
hmm
knowing about it, can you still go back and say, hold up,
right. You can.
Okay, wow.
Now I'm just scrolling through. We're just having a conversation, not giving no legal advice. I'm just saying. Who has some questions? I hope what you're seeing, you might have some questions because I really want to go into something, but I can't go into it unless I'm being asked to go into it. So if you got any questions, I'm going to go back.
Judgment fund, instructions for Form 1 of voucher for payment, please. Okay.
Press 9 phone the keypad if you got any questions about what you're looking at.
Mm.
Um,
So,
hmm
now you said the notaries send this in.
Yeah, all every notary. If you're a notary, you need to have this in your possession. Yesterday.
So after arbitration, this information is filled out by the notary
Right,
and sent in.
right. But see, that's why the notary is working with the client on what you're doing, what you're gonna
So
do, what you're trying to do.
so when you talk about, let's say you went to you've had an arbitration case, and
You got your judgment. You got your truth affidavit. Now that truth affidavit information to be on some of these forms we're talking about, right? To use them and see if you
is
study
there
the
another?
fact. Go
Go ahead.
ahead.
No, go ahead, Mr. Bay.
If there's if you got your fast manual for 2023, because they did one in November and then they did another one I think at the beginning of the year. You get your fast manual
How do you
because they
spell
got it.
that? FASS?
Uh, yeah, FAST, fast.
Oh,
It's a
fast.
yeah, and it's a manual that they give you, which is tell you what type of accounting codes you put behind your transaction. So you put an accounting code, it'll go from a credit to a debit, debit to a credit. You got to put those codes on, in the right place to move it from one institution to the other. That's why I tell you, you call it a general intangible. Now it's going to be either receivable or payable because that lines up with the fast manual. Like, give me a second. Let me show you the fast manual so I'm not just talking foreign to you. So I'm gonna stop the share and I'm going to bring forth the fast manual here. While I'm doing that,
Dr. Bay,
yes, ma'am.
I had a question. I'm
Sure.
sorry.
That's okay. That's okay.
I don't want to appear to be rude, but while you were looking for that,
hmm
um, what if the other party does not want money, like in a foreclosure case? What if they
hmm
don't want money, that they're insistent upon taking the property?
Well, if there's a lien already in place, they gotta restore the estate because they have no legality to the property until the estate has been made whole. Because if you're a debtor in possession, the only way they get the property is you walk away from it, and then they file a claim as abandoned property. Until they have paid the
Okay.
estate for the amount that's owed, that keeps you in the property. So if they want it that bad, they're gonna pay you to leave.
But what? Um, I'm confused because
hmm
in that situation,
hmm
the went back to the courts and said the courts had jurisdiction.
hmm So that
It's like they're ignoring the UCC one.
they can't talk about the UCC one because they don't have any jurisdiction. So they're only talking about the fact that if you're going to perfect your security interest, the person who acquired that property, not the court, is responsible for paying you. So whoever acquired the property, they are the ones that must pay the estate. And basically a cease and desist is put in place until the estate has been made whole. And after their days, if they got 72 hours to make the estate whole, if they got 10 business days, and them 10 business days has expired and no check has been cut, now there's interest that's owed. Now they get a lien put on them. It's bad enough they bought property and the bank didn't tell them that it was a lien on it. It's worse when now, because they done got into this mess, now they owe. They already out of the money that they already done gave the bank for the property. And to add insult to injury, the person who they done stirred up done put a claim on them too.
So should a UCC1 be done against the person that bought the property?
A UCC3 to add them as a debtor to the property.
Oh, right.
Yeah, three. You just add them as a debtor.
But this would be a new UCC. Okay, no, got it.
You'll do a 3. You'll do a 3 and add them to it. That's what you do.
Okay.
Sorry.
No worries. Go ahead, Brother Lamont.
I apologize. My mind is just going super fast.
I know.
I'm hearing you guys talk, but I'm looking at these codes, these fast. I'm in the fast book, and I just
right. Like I got the book up now, so I'm finna so everybody can see it.
These codes are the codes that the IRS use.
These are codes that the Treasury uses, IRS, and everybody across the board uses.
That's
and
what
you
everybody
need to use
them too in your account.
Right.
Okay.
So when you move in value, you're gonna use these codes. And I highlighted this section. You see Part 3. Read that to the class.
Contains foreign currency accounts assigned for use in accounting and reporting for receipts, disbursements, sales for dollars, and balances of foreign currencies originally acquired by the United States government without payment of dollars, and for currencies held in trust. The page number code for this section is FC.
This is the newest. I think it's the newest one they got out. Let's see, it's this. Yeah, this is January. This is the newest one. This one was they had another one in November, and this is the newest one they just issued.
No, I got the one I got open says well, I got the file I have says federal account symbols and titles, agency identifier code, Treasury Financial Manual Supplement, May 2023.
Okay, so it's a new one in May 2023. Okay, gotcha.
I just downloaded it.
Okay, good deal. But these are the codes that you use, and these are the forms that gives you the ability to convey them.
And I want to say too that they did mention that going forward, that I'm going back to the page. It says going forward. Part 2. Starting with November 22 Fastbook release. Part 2 will now be in Excel format only.
So they're innovating to the smart contract, and the AI is going to be making these petitions into the spreadsheets.
Be parsing that spreadsheet. Oh man.
So, Judgment Fund Award Data Sheet, Judgment Fund Transmittal, Judgment Fund Voucher for Payment. Judgment fund voucher for payments, 2-page document. You need that. If any notaries that need this package, please let me know so I can get it to you. I give it by request only. If you don't make the request, I can't just technically hand it to you. But if you need it, I will definitely make sure you have it. Any questions over anything I've showed up until this point?
I could use the packet.
Yes, ma'am. Yes, ma'am. I got you. I got you, Miss Edith. I got you. From here, once this type of package is filled out and you had a judgment fund transmittal, this verbiage now can be put in a different transmittal letter like this. I'm going to go back. This one takes it out of the CRIS. The client is going to need some sort of transmittal letter. The client is going to be issuing this type of transmittal letter. The client has to understand that there has to be a transmittal letter, UCCs, a letter of credit, and a money transmitter bond to move it from one place to the other. What I'm giving you is the the bologna, the meat, and the mayo for the sandwich. I'm giving you all the stuff you need to make it move where it needs to go. The notaries aren't allowed to give legal advice, but the notaries can give notarial advice. So let's talk about this from that standpoint. This is a money transmitter bond. I used to use an agency called Transworld Systems, TSI, but I've worked with them for so long, they've gave me my own platform, so that's why I no longer use them. I've used my own. But if you've already invested into the private banking manual, you still have all the verbiage to design the money transmitter bonds and everything else necessary. These are your instructions. This is your Hague Convention. You can see your UCC 5. I'm looking for questions now because I think I might have went too deep, too far, and I don't want to go no further unless you need me to go further. You got any questions?
What
comments?
if you don't have it?
Go ahead.
I'm sorry. I knew you was going to ask that. What if you don't have a UCC-5, but you have a judgment lien?
The judgment lien could still be placed on the UCC-5. Remember that UCC-5 has 3 distinctive points, and it's about correcting statuses. It's a correction form. So
what if there was never a UCC in place by the entity?
Okay, now the UCC-5 isn't about them. The UCC-5 is about you. The UCC-5 lets you, if someone has been damaged, pay them. And if they haven't been damaged, or let's say it another way, I'm going to say this probably just this one time in this class, and I don't want nobody to misconstrue what I'm saying. If a UCC-5 is used to issue credit, and it doesn't matter who it issues credit to, its job is to issue credit. How can you make that work for you in this scenario? Now I'm finna say, I'm gonna take my accounting hat off and say if it was me. If it was me, and I was in a scenario like what you're in, Miss Bess, I would use the UCC5 and issue myself some credit. And then I would go and get another mortgage on the property and get certain things done to it. And let them figure out what they want to do because they still owe your estate. But I wouldn't be waiting around for them to make the next move. And I would use these forms, issue the estate some credit since they ain't cut you a check yet. And when they do, it just goes on the back end. The thing about UCC 5 is all the way up until you do the 5, if you're in that debtor position, mind state, and you're being victimized by them, then you're that victim until you come to that 5. When you become the 5, you stop being the victim and be the change that you want to see. When you put stuff on that 5, it's a settlement form. So if I want to totally, there's a form called a 1099-C that's designed to cancel debt. So if a property is being foreclosed and I fill out a 1099-C because there was a credit issued on a UCC5, that nullifies foreclosure. And because they done sold it to this poor schmuck who's trying to figure out what he gonna do, unfortunately the bank is off the hook too. Now this poor guy who got this property, he's in a world of trouble. They got to pay your estate. They got to pay the IRS. They got to answer to everybody, and he wasn't giving full disclosure. Now, you're not being facetious and mean because you want to move on with your life. This is your aired property. You didn't start this process, but you ended it. In this game of commerce, it's a merry-go-round. And once you have put on your helmet, your knee pads, elbow pads, and you're going the proper speed, you now got a permanent place on the merry-go-round. But if it's anybody on the merry-go-round that don't got a helmet or elbow pad, when you get settled, that forces them off the merry-go-round. And when you go from UCC 1, 3, when you do the 5, that's going to force somebody that don't have this stuff off the merry-go-round. It's musical chairs. Now,
do you have a UCC5 that you can put on the screen? I'm sorry.
Yes. It's an information statement. This is a UCC5 right here. It's just basically an information statement. And if you can't find one, just let me know, and when I send the other documents, I'll send this one.
Now let's go back to those 3 questions you were talking about. Is that it right there?
Yep. Record is inaccurate. Record was wrongfully filed. Record filed by person not entitled to do so.
Record is incorrect.
Right.
I'm setting it straight.
Right. That's what you're correcting the record. Correct.
Gotcha.
All righty. Any other questions over anything we're covering up until this point? If you got any questions, please press 9-4 on your keypad.
I got a question.
Sure.
So, we're talking about things could be insured and reinsured.
Right.
I'm going to that, and I hope I'm not going off topic. Um,
Mm-hmm.
I think it's all relevant at the end of the day.
Mm-hmm.
So I'm looking at. So when you say that,
Mm-hmm.
uh, let's just say you don't have. Okay, let me back up a little bit.
Mm-hmm.
Are we talking more of errors and emission insurance, or what type of insurance are we talking about? From a
There's all types of insurance. Let's clear the air. Like I'm gonna kind of talk about insurance that you never even heard about when we get into how to leverage equipment leasing with Go Capital, because that's gonna be the other part of this class we're gonna get into. There is insurance for everything that you can think of commercially. If there's a transaction that can be done, that transaction can be insured. Like if you are building real estate, then they got an insurance that covers the building of real estate. If you're going to manufacture a car, there's an insurance that covers you when you're manufacturing a car. If you're going to paint a building or paint a mural, there's an insurance policy that covers you as an independent contractor for painting a mural. If you are actually participating in commerce and you run an online virtual store and you got a website that people in Nigeria can go into, they have a trade credit insurance product. There isn't anything that you can think of in commerce that they don't have insurance to insure that engagement. The object of the game is that you have to identify, call whatever magic pill you're making, prayer rug you sewing, whatever it is you're doing, you have to call it one of those types of items that can get that item commercially insured. So that when the person who receives it, when they get it from you, they can get it reinsured. If your product or service has the ability to be insured and reinsured, then funding is just a matter of filling out the right form. Did that kind of help you out a little bit?
so basically that it has to be an asset that could be insured or reinsured.
Have to be a tangible that can be insured. Intellectual property, trademarks, ideas, those things can be insured.
Okay, thank you.
Okay.
Cause I was looking at
Mm-hmm.
I was online just looking at different insurances, and that's why
All
I
right.
asked. Because I see
Correct.
like on this company called Hiscox, for example.
Yes, they do. I deal a lot of business with Hiscox.
Yeah, I see professional liability
Mm-hmm.
insurance.
Mm-hmm. E and O and all that good stuff. Yeah. General liability. Yes. Yes. Great company. They do a lot of things.
Okay.
Any other questions pertaining to anything we talked about up until this point? If you hadn't had a chance to ask a
Question.
question, sure, go ahead.
Those documents that you would submit to the in response to court paperwork that comes, do you respond to the court or do you respond to the people that sent it?
If the court sent it, then I would send it back to the clerk of court because they are the ones that are actually providing that correspondence. If it's somebody who is sending it to me and they're using the court, then everybody will be put on notice. Like the correspondent is going to tell me who I need to respond to. For example, if the court ordered something, that means there's somebody else behind the court, like somebody that's holding some sort of interest. So at the end of the day, everybody who has not paid the estate owes the estate, and they're going to be forced into involuntary servitude either by association or by direct contact. So when I do my UCC 5, my UCC 3, and my 1, I'm adding debtors to the pile of bodies, and I'm forcing each participant in involuntary bankruptcy until the estate has been made whole.
Well, at this time, would they say it was too late to do that?
It's never too late to perfect your Article 9 security interest. Those timelines have nothing to do with your timeline. Like, if you already got a UCC in place and they do all what they're doing, that has nothing to do with your UCC. That's them trying to get out of an obligation that's on their book because they reported to the IRS it was something that it wasn't. You got to remember there's a whole history of what they're doing that you don't know, but I'll say it for the record so you'll get it. They destroyed records 36 months ago, and nobody can tell nobody who owes what. So when they try to come back around and make a claim on this property, they hope you don't have no records either, because the IRS destroyed over 3 million business returns. So everybody now got to show their books. And we all know if you ain't got no UCCs, you ain't got no books. So they're hoping that since they ain't got no books, but they can scare you off the line, you ain't going to have no books. You were smart enough to at least get a UCC saying, well, if you're trying to do this, then show me the document so we can get the show on the road. They never showed the document because they don't have it. And plus, a UCC has to be renewed every 7 years. What they got is a stale claim, but they only are on the chopping block because the IRS destroyed records 36 months ago. During COVID, everybody's books got scrambled. And the IRS just says, well, they went out to the dumpster on the back of the building and just threw all the files in it. Some of these files had checks in it and everything else. People actually paid their taxes and they lost their entire file. So right now, if you're trusting any of these alphabet agencies and you got a UCC in your hand, all they got is paperwork by somebody else and nobody's trying to answer because, see, the agency that's making this claim of foreclosure is Ginnie Mae. And MERS cannot make no type of claim like that. USA Bank is Ginnie Mae. They had to change the polarity. That's why they started a trust. They're just trying to put it in another name to keep the Ponzi scheme going because that mortgage pool, they're still trying to get a dividends off of it. And the only way they can, if you argue with them, if you're not arguing and you're making it strictly a tax issue and you already got a UCC supporting your claim, now their problem ain't going to be with you anymore. It's going to be with the IRS. Let them battle it out on who shot John and who owed what. Unfortunately for the guy who supposedly said he bought the property, he's going to be upset. Very upset because he was sold property as is. There is a lien for over the amount of what the property is worth. He can't get a mortgage on it. He can't do anything with it. And if he keep tongue wrestling with you, he going to find himself in a commercial claim when his debit card going to stop working. It's all good when you can get it for free and nothing and people walk away from it and you abandon it. It's another thing when I got to pay more than what it's worth.
Well, the law firm for the people that bought it is the one that's trying to get rid of possession.
Right, and that law firm has a public hazard bond, so they will get a claim put against their surety. And if they keep getting claims like a person who keep having wrecks, they ain't gonna be practicing law too much longer. I mean, you're getting too many claims. I'll give you an example. How many people that are in your trust? Let's say it's 10 people. So that's okay. every member in the trust making a claim, not just you. I'm gonna tell you the fastest way to lose your bond. Have 2 claims in 30 days. If you get 2 claims in 30 days, they will drop you. They will keep your money and say, we can't do business with you no more. You are high risk.
Okay.
So that's where that lies. So the law firms got to have a public hazard bond, and they'll be added to the claim like everyone else. Now, again, the law firm ain't gonna want to be held liable. Everybody gonna be pointing at everybody else, and it doesn't matter who you're pointing to. All you're saying is that I don't care who signed the check, just send it. But since I ain't received one, I had to tell the Attorney General what y'all doing. I had to tell the Secretary of State what you're doing. I had to tell the Treasury what we're doing, and I've already got a judgment bond with the Bureau of Fiscal Services. So now you got to answer to them people. Ginnie Mae ain't gonna do all that, 'cause they're gonna be like, first off, that's just a bad loan that you just got to eat. But they were smart. They found somebody. They found them a sucker.
Yes, because remember they forwarded the bid.
Yeah, that's what I'm saying. They found, they did their part. And when the heat get too hot, they're gonna definitely get out the kitchen. At this point, it can be a peaceful resolve. He put in a claim, just like you put in a claim. He get his money back through the Treasury. He go on to another property. You go on and renovate the property and move on. What's going to happen, though, if they persist, is you still going to stay in the property and move on. It's just going to get real salty for him.
So therefore, correspondence needs to be sent to the attorneys asking for the bond and insurance information.
Right. And their failure to do so constitute insurance fraud. So keep in mind, knowing that they got insurance, they got to have it to operate, and you're making the request and they're not giving it to you, violates their policy. They have to give it to you upon request. That's why I read that in the arbitration proceedings. When you go back and listen to this class, you're going to realize when I started this class, I had the affidavit of arbitration, the affidavit of obligation, read out with all 32 maxims. And the last one was about the public hazard malpractice bond. And that's the reason why if they have to be bonded and insured, you have a right to ask who that company is, and their failure to produce that is prima facie evidence. When they don't give you their bond, you have to put a lien on them. It's just you didn't know you had to do it. You're thinking it's a choice. Commercially, you have a responsibility that when you do business with anybody, you ask them for their bond and insurance. It's just like you're riding in the car. You're on the freeway. They run into you from the back. You get out the car. Just like the police ask for license and insurance, you probably asking for license and insurance.
Well, while we were talking, I printed out something that I got off the web, and it is an affidavit of obligation commercial lien, and it says this is a verified plan statement of fact, and it has the maximums on it.
Yes.
But it seems like a whole lot more than 32.
Oh yeah, but that's what we use for arbitration. It's the same thing.
Okay.
But that's definitely that's your grounds. That's your grounds for enforcement. Hold on for 1 second. Then we got another question. Brother Mark, can you hear me?
Yes, sir.
All right. Talk to me. You got a question?
Yeah. First of all, I need a copy of the paperwork, and the second part is how do you get security bonds on yourself or put on your trust?
Couple of ways. always refer to yourself like in third person when you make those type of questions. It's gonna be easier for you to understand the responses.
Okay.
Don't associate yourself in commerce as the sentient soul, man of the land, child of God. When you're in this artificial construct, you are legal fiction, a corporation. You are a legal entity. And all legal entities in commerce have the same ability to be protected under the Constitution. And one of those rights is to be the right of indemnification. Now, you can go to a third party and fill out an application, and they'll put it in a commercial registry, and that information is then certified. And then from that position, a group of individuals that feel that your life or business activity or both is worth insuring because you provide a service that produces, fruits and labors for other individuals, and they can all get together and share in that risk by joining under contract for suretyship. Now, that's third parties who don't have anything to gain other than your premium every month and investing that premium into another security platform. If that doesn't exist or that's not appealing, or you just decide, well, you know what, I got some substance under my family name, so I really want to go a little more personal route. Now you can use the right of identification and utilize the stuff that you already got. But now you got to think about yourself a little bit different. When you're looking at yourself outside of the Bible and whatever religion that you are professing, in the commercial video game, you are substance. And they can call substance 15,000 different things. But as long as you one of those 15,000 things, based upon the type of substance you're called, think about it like a video game. It's like you're a puff of smoke, but that puff of smoke is made of carbon. You're carbon based, and carbon based means you're made of melanin. Melanin goes for $480 a gram. If you're 150 pounds or more, you're worth over $32 million commercially. So that puff of smoke that's on the board minimally has a commercial value of about $30 million. Now, whatever that puff of smoke becomes, if that puff of smoke becomes you driving trucks, you working for this particular company, you're the CFO of another entity, all of that is layer upon layer like a multi-layered cake of that puff of smoke. The more value that you have in the commercial zone, the more value they can extrapolate from your estate. So this puff of smoke is becoming an estate. Now, you have the right to insure and self-insure, privately bond and insure that estate, just like another person can take out a policy and insure you yourself. Can you do it? Yes. What's the best way of doing it? I need more input. Is there resources to do it? I got a whole army of resources that'll do it. I have a website that for those of you, now this is not everybody that's in the Diversity Trust Limited Bitrix space. One of the fiduciaries just launched his banking platform. Well, I can say he just launched it. He's in the third year of a new platform. He has a new platform every year. He graduated 3 years ago, and he's been doing platforms every year. Just hit me with the new intel and the new website. I will give all of you guys that are in that space access to his platform. And when you on board with him, you'll see very quickly all this stuff that we're talking about, how to bond, this, that, and so forth. Now, Brother Mark, I don't think you're in that space yet, but there are a couple of brothers that are in this class, like Brother Jarvis Bay. I think he's in the class. Get with Brother Jarvis because he is one of the ones that is in that space. And we can definitely put something together to get you across the finish line. Can you hear me?
Yes.
All right. All right. Any other questions for me? All right. Let me go. Matter of fact, I think Jarvis got his hand raised. Let me see if I can bring him on right quick. Brother Jarvis, can you hear me?
Hey, Brother Bizzle.
All right, man. Talk to me, man. I know you. I just realized just seeing you and the other guy's hand raised, man. I done got excited, man. We getting to the finish line of this thing, but we ain't even got to the good part yet. But talk to me.
Well, you answered my question on the UCC 5 with the
Uh-huh.
So now I ain't know if we could change variations. I wanted to know more about the on the other end when you actually you're selling the MTN or any security.
Right. Okay. So let's talk about the selling of the securities. Now, let's say for conversation purposes, you got a $10 million arbitration award and you are in the real estate transaction. So you'll subtract that real estate transaction from your 10 mil. That difference, that's what you're looking at in the aspect of what's on your portfolio. Now, the best way to sell that type of scenario, in my opinion, is to do an MTN. And I would break that remainder up into tranches. That's like denominations or sections. So if I got, let's say, out of 10 mil, you are working with 7 mil after all said and done. Then I would take 7 million and I would break that up in the tranches of 10. So I would divide 7 million by 10, and that would be a tranche. And each one of these tranches, I may designate different values of premium or par. For example, in the MTN space, like my guy who's got this platform right now, he got some real awesome numbers, and they do fluctuate. How many of you guys been to the new website? Because I got the landing page up for legaljacks.com. I posted it up on the Bitrix the other day, reposted it again this morning. New features are coming as we speak. If you visit the site, you'll now see that we got part of our banking in the box widgets up there for one of our terminal proponents, which gives you like real time stock quotes, this, that, and the other. And one of those tickers, it tracks currencies. Now, what he's offering, if you took your trust certificate units and backed it by the MTN, whatever you bring to them. So if you took 7 million divided by 10, what would that be?
700,000.
Okay, so basically you would sell 700,000 at a discount, so they can control 700,000 for 500,000. Notice how I'm going to say this. So if they can secure half of that 500,000 in what you'll call an M1 and the rest in equity, you will let them control that $700,000 tranche. Now watch this. If they hold that tranche for 90 days, that $700,000 tranche will be worth $70 million. Now, the guy who I'm telling you about, that's the platform he's working as we speak. That's why he told me to give you guys a website today. He's got about 10 more seats because he's only dealing with trustees that are dealing with M3 assets. It pays out every week. So that difference is paid out every Friday. And it's 20 weeks. I think you're right at about we're already at over half the year's gone. It's 52 weeks in a year. So for the rest of the year, every Friday, you'll receive that interest payment every Friday. So if you short sell that tranche, that's the power of it, because everybody who touches it, they're able to make more securities off of it.
Got you.
So just work your math. I'll walk you through the application process. He got a whole onboarding system with his website.
Got you. Lovely, man. Lovely. I can't wait.
Hey, it's time to do it. You got any other questions for me before I jump into this equipment leasing stuff?
No, that'll be it for me.
All right, let's see. I'm gonna go to my man, Mr. Keanu. Big bro, Mr. Keanu, can you hear me?
Yes, sir. Yes, sir.
All right.
Yeah,
I hope you're learning. All right, man. You learning something, man?
Man, I'm blown away. I'm just trying to keep up.
It's okay. It's okay. Talk to me. What you got for me?
Yeah, I was wondering, could you give me that website again? I got a whole lot of questions, but me being a newbie on this platform, it seems like you got a lot of things going on, and I'm like a kid in the candy store.
I know. I got you.
Everything.
I got you. I got you.
Yeah. So like when you're dealing with the UCCs, when you're trying to, are you like taking the assets, or are you taking, for example, like your birth certificate and then registering it under the UCC, or are you doing the UCC?
Let's talk about that, the authenticating of the birth certificate. I take an approach where I talk about that process from an accounting perspective. So indirectly, you learn how to do that, in my opinion, the right way that doesn't cause conflict. Because, see, I'm not allowed to talk about the bartering and trading of securities unless you are licensed to handle the bartering and trading of securities. And the mere fact that you're talking about monetizing a birth certificate falls into that solicitation conversation. Now, I can indirectly, if you're telling me that this is your authenticating documentation for value, and you can associate your birth certificate with a value, like, I don't know if you, and you got to listen to this class a couple of times to really get why I'm saying what I'm saying. Another gentleman asked a previous question earlier, and I associated him being a puff of smoke to melanin that can be justified as a cost. So if you can take what you're talking about with that birth certificate and tie it into something tangible. The birth certificate itself is tangible, but it's governed under the Securities and Exchange Commission. So yes, if you're going to actually, in my opinion, now my opinion is going to come out. In Bazel's opinion, this is not legal advice, this is just my opinion. Do not talk about authenticating the birth certificate unless you're ready to pay $230 to get a CUSIP. Because now we can have that conversation. That's what it costs to get a CUSIP number. $200. You can go to the DTCC and buy a CUSIP and then use the information off your social, and now we can have that type of conversation. But guess what? It's going to ultimately end up with, okay, your birth certificate for the government is based upon your future labor. What are you basing this security on? That's why I don't go in that direction. I take the accounting approach, so you will learn, oh, I can do the birth certificate because really I'm supposed to use it with the system, not pull it out the system. That's why, if you want to collapse the trust, because some people say, well, you got to collapse the trust, this, that, and the other. My opinion is it's real simple. All of that stuff, birth certificate and Social Security and stuff and all, that ain't your shit. That's their shit. So if you want it to be yours, you're going to have to create something from it. Now, if at least you pay $230 and got a CUSIP, we can now talk about how to monetize a CUSIP. And that's the conversation that people want to have about the birth certificate, but they're on the wrong side of the conversation. Remember, you can't start using these UCCs and discharging debt until you've done this one thing. That's forgive the debt that's owed to you. You know how many people fail that test? This is what they want to do. They want to hypothecate the birth certificate. Hypothecate the birth certificate. Why? Because it's got some money in it. That ain't your shit. But they can't get around that. They like, but they use it right because that's their shit. look, if you create your own. They don't want to do that. They want to. It's like you come to my house and want to use my shower, wear my bathrobe, and then when I say, okay, well that'll be $100, you don't want to pay, but you use my shit. That doesn't work that way. The government ain't say they're gonna be your daddy and your mama. We just think we think that's what they. To answer your question, brother, you can definitely do that, and we do get into those type of conversation. But as a notary, you kind of learn, there's a whole other way you're supposed to be using that. Now, and I got clients that are hell bent on authenticating their birth certificate. I just make them do a whole bunch of affidavits and indirectly teach them to do it the right way in accounting.
Okay.
They don't. If I tell them you're going to have to learn how to operate a trust and this, that, and the other, that'll deter them. I just let them run into that brick wall. Like, Mr. Bay, I can't do it right. It's not about you. You can't do nothing. You can't do none of this stuff unless you're operating in trust with a notary. You're going to figure that out. The first time you ask me how you're going to do something, I'm going to tell you exactly how to do it. And you're going to be like, man, I don't want to do all that.
Right.
It's not, and the only reason why you're saying you don't want to do it because it sounds like it's a lot of work. It really isn't. It's just that's the system. That's why they have a perfectly good hammer that can hang up paintings. But when you don't do this accounting, it's like you're using your shoes to hang up a painting. Now the shoes are made to go on your feet, but it can hang up a painting. And that's what when I hear different clients talk about monetizing the birth certificate, I'm hearing a whole bunch of people. Because see, how many people? I'm gonna tell you my experience with the birth certificate. Because I authenticated my birth certificate. I went, I got it, I did all that stuff that I was trained to do. I was too stupid to stop. I'm just gonna put it out there. I was so stupid that I didn't stop. That's how I learned how to do it. It was never like, oh, well, they said this. That just meant I had to go through another door. I didn't expect them to let me in. I kicked the door in.
A question on that.
Mm-hmm.
Not to actually to your personal business.
Mm-hmm.
So I authenticated my birth certificate.
Right.
All right, and I'm gonna just the process that I went through.
Right.
I mean, I don't know how many ways to do it, but one, and
right.
it was just to send mine off to Secretary of State.
Right.
They authenticated, put this,
right,
piece of paper on it, and that was it.
That's it.
And then so actually I did two.
Right.
I did an authentication of my live birth.
Right.
Which was that long form.
Mm-hmm.
And then hold on, let me back up. I apostilled that one.
Mm-hmm.
And I authenticated the other one, the
right.
short form.
Right.
So when you say you didn't stop,
right.
I'm not not to pry into you. What's an example of not stopping after that? I mean,
not stopping is till you come to the point where you're gonna end up with that form that says Bureau of Public Debt.
Oh, okay.
Because it's gonna all roads lead to Rome. You're gonna end up there.
I got you.
You're gonna end up there.
Got you.
If you do it right, you're gonna end up right where I just showed you.
Got you.
And as a notary, when someone wants to do the birth certificate thing, they're gonna end up there. But it shows competency when you know that it used to be the Bureau of Public Debt. Now it's called the Bureau of Physical Services and blah, blah, blah. Because that's how they test you. They change names. They're all trusts. When you understand that you're a trust and you can change names too, Paul Mooney said it best. And this is an allegory that I want you to start using because my elitist friends, they say this and they're kind of poking fun at us. They say, look, when you realize you free, white, and 21, you'll get it.
Hold on. Say that one more time. When you realize you're free,
When,
white,
when,
and 21? Is that
right,
what you said?
right.
Okay.
When you realize you're free, white, and 21.
Okay.
Those are keys to commerce. See, when you're free, meaning you're not bounded by no system, no ordinance. When you white, that's a political status. And when you're 21, you of age. There ain't nothing you can't do. It's just rather what the time and energy are doing. Now, as long as your thinking is that you're not thinking like you free, white, and 21, the greater has influence over the lesser. It's a polarity.
Okay.
It's a polarity. So, yes, brother, we get off in authenticating the birth certificate and things that sort, and there's many roads, but the fundamentals are few. It's many processes. Like you're gonna take what I just said and come up with your own remix, which is what you're supposed to do.
Okay. Can you send me those forms from
Definitely.
physical service?
We'll do, Brick Bro. I got you. All right. Any other questions before we get into the equipment leasing side? Because this is going to be pretty interesting. All right. If we don't have any other questions, now I want you to pay attention to, I'm going to share my chat GPT screen. Okay. Hopefully it'll come up this time. Yep. There we go. How many of you guys can see my chat GPT screen?
Yeah, we can see it.
All right.
I can see it.
Beautiful. Now, this is for everybody that is a notary who has already become a loan officer with GoCap. I'm gonna put everybody on mute so you can definitely not miss this part. All right. Let's see here. Let's go back. Here we go. All right. I was talking to a trustee earlier today, and I got into a conversation that sparked putting this together, and I decided after I put it together that I need to teach it in class. But in order for me to give it proper proponent, I'm going to give you a term that I want you to look up. The term I want you to look up in your chat GPT is this term called market neutral. It's a term called market neutral. I actually gave the chat GPT instructions. You are a stockbroker. Can you draft me a detailed outline about becoming market neutral? Let me explain to you market neutrality. First, you got to understand the definition of it, the philosophy behind it, and the strategies, the benefits and risks of market neutrality. You got to also understand that there are strategies in terms of how you use this in the aspect of investing. You have what they call short and long equity strategies, buying undervalued stocks, short selling overvalued stocks. You also have what they call pairs trading, buying and short selling two correlating stocks within their divergence. You also have what they call convertible arbitrage. Convertible arbitrage, which is the buying of a convertible bond and short selling the underlying stock. You also have what they call merger arbitrage, which is the trading of stocks of merging companies. Then you have what they call capital structure arbitrage, which is exploiting prices inefficiencies between a company's debt and equity. Now, as you can tell from this outline, market neutrality sounds like some really high, sophisticated type of trading structure. And it is, and they pay a lot of money to learn how to do this. Now, here's the advantage that you compliance officers have that I didn't have. When I had a Series 6, a Series 7, and 63 license to be a stockbroker, we used to have to spend money to learn how to preserve market neutrality. In other words, the ability, no matter you made money whether the market went up, down, left, right, or sideways because you had strategies that played off of these variables. Your homework is to develop a market neutrality structure for what you finna learn about equity finance leveraging. So when I went through this conversation, as you can tell, this was a very sophisticated conversation because it started out with market neutrality. I ended up talking about equipment leasing. And when I started talking about equipment leasing, I ended up with this thing. And this is what we're finna go into. If you are a loan officer with Go Capital and NAC, then both agencies offer equipment leasing and financing. Now, this is just my thought process. After talking with various different fiduciaries about these products and the commissions, it seems like a lot of folks are still in their head, oh, how can I market this? Who can I give this to? Who's going to take advantage of it? Let me give you a scenario. How many of you guys have ever heard of Lyft and Uber? Has anyone in this class ever heard of Lyft and Uber? I'm gonna go ahead and now I'm gonna unmute, mute your. Well, let me just do this. I see hands that are potentially raised, so I'm just gonna pick. Okay, I'm just gonna pick Lamont. Brother Lamont, have you ever heard of Lyft?
And no. What is
okay.
Lyft and Uber?
You ain't never heard of Lyft and Uber, man?
Come on, man.
Okay. All right. So if you've heard of Lyft and Uber, what if you provided equipment leasing for individuals that are in Lyft and Uber to expand their Uber business? See, most people when they go Ubering and Lyfting, they're using their vehicle. But because I gave you asymmetric information, every dealership that you pass, all those vehicles the car dealership don't own, those vehicles are all in trust by the manufacturer. So you can easily create an equipment leasing scenario with the dealership. So I want you to think about whoever you know that is doing Uber and Lyft as a potential franchise owner and not just doing it for extra money. Follow me? If they're doing it for extra money, they'll definitely follow owning and controlling a rideshare franchise. That's what we're going to call it. Rideshare franchise. I ain't lost nobody, right? Lamont, you still with me, right? You understand what I'm saying? That makes sense to you? You following me? Mark, are you following me? Okay. All right. So I want everybody to understand that now that we're in this conversation of rideshare, I asked ChatGPT to generate me a detailed outline for a financing opportunity for Uber and Lyft drivers to opt to apply for equipment leasing for their fleets. And here's what we came up with. We came up with a market research analysis. We had a product development scenario. We got an eligibility criteria, an application process, an approval process, a lease agreement, delivery and installation, and consumer support. Well, but Mr. Baby, before you go into all that, am I hearing you right that Go Capital will allow equipment leasing for this type of ordeal? Let me be real clear. Go Capital says their minimal invoice has to be minimally $25,000 on equipment. And if we get into commercial vehicles, minimally $60,000. So, how can you make this rideshare franchise fit into the scenario? All right, so after it gave me these steps, I asked ChatGPT to execute market research and analysis. And this is what it came up with. It said Uber and Lyft drivers need to maximize their earnings while minimizing their expenses. This includes the cost of the vehicle, fuel, maintenance. They also need reliable vehicles that meet the requirements of ride-sharing companies and provide a comfortable experience for their passengers. The type of vehicles used by Uber and Lyft drivers typically are vehicles used by Uber and Lyft. They vary, but they often include fuel-efficient cars and hybrids. Some of the most commonly used vehicles include Toyota Priuses, Accords, CR-V hybrids, and other popular, which include Toyota RAV4s, Primes, and various models like BMW, Cadillac, and Lincoln. The average cost of the vehicles used by Uber and Lyft drivers, the cost of vehicles can vary, make and model. Here's the money shot, 38 to 41. Now, that meets one of my demographics because the minimum invoice got to be 25. So, okay, on the most commonly used vehicles, we meet that criteria. Here's something else that I found interesting. Rideshare hauling market is substantial and continues to grow. The market is expected to reach in the United States dollar 179 billion in 2023. We're in 2023, and grow at a compound annual rate, which is called the CACR, of 8.75 to reach 272 billion in 2028. Uber dominates the market with a share of 50% compared to 19% for Lyft. However, drivers often sign up for multiple services and indicate a potential overlap in the market. Pretty good information. I can definitely use that data. Next, I said execute product development. So when I asked the AI to generate me product development, we came up with the product name. We said rideshare fleet leasing program. The terms should be flexible to accommodate the various needs of the drivers. Options could include short-term leases of 1 to 2 years, medium-term 3 to 5 years, and long-term 6 years plus. Lease amount will depend upon the type and cost of the vehicle. For example, a new fuel-effective car might have a lease amount of around $300 to $400 per month. The lease amount should be competitive with other leasing options available to drivers. Interest rate, depending upon credit scores, should be 3 to 7%. Payment schedule should be monthly to align how drivers typically receive their income. This could be also an option for biweekly payments for drivers who prefer this schedule. You got early termination options. We got the maintenance and repair service. We got vehicle replacement option, end of lease option. So this is a pretty good outline. So everything I'm seeing so far, I'm moving in the direction. Now this is where it got interesting to me. I asked it to execute the eligibility requirements. It gave me the driver's experience minimally of 1 year. This ensures that they have the basic level of competency and experience on the road. Then it says rideshare experience. Applicants should have at least 6 months of experience as a ride-sharing driver, which means you need to already be, if you're going to come into the program, you're going to have to already be driving for one of these companies for at least 6 months. Then this is the money shot, because I done already crunched the math on this. Is why I'm bringing it to you guys. And yes, I've already got this approved with Go Capital, because what I'm reading to you is what I literally read to him, and he already gave me the green light. Applicants should have a minimal credit score. That exact score can vary, but a common minimum is 600. So when I talked to Jacob at Go Capital, he agreed that if they meet the 600 credit score, they will entertain this. Income level, all of this. Driver record, of course, got to be 21. Insurance. Applicants should have valid auto insurance policies. These policies should provide adequate coverage for ride sharing. This is what got me really excited. Now, if you've ever used Lyft or Uber, you get to pick the type of ride you want to take. Now, of course, every time I usually do Uber or Lyft, I usually take the VIP option because they're better vehicles. They wait on me. You know, it is what it is. That's how I roll. Um, and usually somebody will show up in a high end type car or something like that, and I usually don't have no problem because I usually go places where I don't need to be showing up in a hoopty, this, that, and the other. So I got to thinking about my experience with Uber and Lyft, and I said to myself, well, I know some folks that can actually get $50,000 vehicles and it only costs 19,000. Of course, if you want to know more about that, these actually one of the guys that's actually in they're in the space. They told me to put it out there, give them the pitch because they're trying to generate some revenue outside of what we're talking about, and that's what they're doing. Case in point, we got into a conversation in that regard, and they was, everybody's trying to pick my brain for ideas. And again, I said to myself, aren't you a loan officer with Gold Cap? It's like, yeah. So now this is what was running through my mind when I was talking to them. It's just today's conversation. I was like, well, I'll stop talking about it and start being about it. Now I can bring it forward to the class. Well, as long as you can get the person who's selling you the vehicle to label those vehicles as commercial use, then you can use the equipment leasing program with Go Capital to acquire a small fleet. Now, this is how I think. I would do if me implementing this, because I'm implementing this as we speak, I'm looking to utilize this with a tractor, a tractor truck, a trailer, a box truck, and a dump truck. That's how I'm thinking. Now, because I've already talked about 10 or 15 people earlier today, everybody who's in that space, now, if we're doing tractor trucks, dump trucks, and box trucks, and if I happen to need a BMW and a Cadillac, well, that's just part of the furniture. That's just the perk. That gets thrown in. The lease is going to be paid for. I just need access to that vehicle. I don't physically do any driving these days. I have folks that drive for me, but, they might want to drive a BMW or a Cadillac or something like that. So having access to one, because we're already doing this stuff, made sense to me. So when you get into talking about being a lender that offers equipment leasing, and you have Go Capital that's willing to be your lender, this program is pretty solid. Now, it's left with enough room in it for you to do some subtle tweaks, especially with the lease terms and maintenance and so forth. I also had it draft me up a lease, just to demonstrate that it definitely could be done. After I got all this together and got the approval for Go Capital, I said, well, maybe I need to go ahead and tell the rest of the group that this is something that they could actually do, because I have a lot of folks that become new loan officers, and it seems like they can't find nobody to sell money to. I don't think if you got a person that's seriously doing Uber and Lyft where they can get an opportunity to get 5 vehicles and make a percentage off each vehicle, than them just chasing what they have going on. Now, again, it's going to take you having a solid business plan and this, that, and the other. But if you are, and I'm just solely introducing this to the class because the power of leveraging, this is what I was getting to. You can do an indemnity bond for $1 million off of a general liability policy. So the company will have $1 million policy, and they will take out of that $1 million policy $100,000 to insure these vehicles. Now, if you got a good credit person, a portion of, if the vehicle is only worth $40,000 and you got $100,000 slate in $1 million policy, then the remainder of that can be monetized, bartered, sold, and repackaged. Let's kind of back up to an example that's different but the same. For convicted felons who have gone to prison, and when they get out, the federal bonding program gives them a bond that they can bring forth to a potential employer, which the person who receives the bond has the option to hold the bond, collateralize the bond, or liquidate it because you're taking a risk of hiring that high-risk employee. Well, same thing applies when you take general liability insurance and break it off into commercial insurance for equipment because it's about equity. So even though the vehicle may depreciate by use, that insurance could actually get you into a much more stronger position equity-wise. Now, for all intents, purposes, and legal purposes, if I'm asked to expound on certain aspects of what we're talking about, then I'm obliged to do so, but I don't want to go past the solicitation line. I'm just simply hoping that you see the opportunity to offer this equipment leasing as a ride share franchise opportunity for all those that are participating in the Lyft and Uber perspective. At that point, again, I'm holding all my happiness inside because if you guys really get it, then we really can turn up with this. But if you need some more clarity or you want to ask some questions, I'm going to go ahead at this point. And if your hand is raised, I will open up the line here. Let me see. So, Jarvis, let's see.
Greeting, brothers. Is
Is your hand raised or it was raised from before?
Yes, it was raised from before.
Okay. No questions on what I just explained?
Well, my question would be, how would approach that in the? So you're saying I have to get a real estate, like if I'm in the real estate.
Uh-huh.
I would have to get the actual seller to
Right.
sell me the property as
This is what it is. If it's a property, like I'm gonna give you a scenario. Let's say he's selling a house, and I want to use equipment leasing. I would have him invoice me as this. This is an office space. It's a lease, and this is what it's gonna be.
Gotcha.
Then I can go if I'm going to use that under the equipment leasing. You do have, you got commercial mortgages and all that. So you got products specifically for real estate. I'm just simply talking about equipment leasing because if you really get how to leverage it, we're going to get to this gray area where it really gets interesting.
Oh, yes, of course, because with properties, I'm going to need, of course, lawnmowers.
Right.
Cost of transportation.
Right. So these are things that Go Capital will go ahead and buy for you on behalf of the company. So they go get the equipment. So you give them the invoice, they pay that company for it, and now you're paying Go Capital.
Gotcha.
And we can get into a very interesting conversation if you really put your thinking cap on, especially if you circle back to this Uber and Lyft rideshare financing franchise.
So using the narrative, because Uber would be one, but knowing that you can do multiple franchises, going in a different way.
Right. Like you would actually, people who are driving for Uber and Lyft, if they had access to 5 vehicles, that's 5 different drivers under their company.
Exactly.
That part.
Exactly.
Now watch this. If you're doing equipment leasing, what if you had access to a fleet of Maseratis? Right.
That's an asset.
Right.
Also can be leveraged.
Right.
So
we can get into a.
You can leverage that asset to do more.
Right. So if you decide to get you 4 Range Rovers.
Exactly.
So we can get to a very interesting conversation. Just like the trucking, you just want the wheels turning. You don't want to have no inventory. You want them all gone. I would do 90-day leases. I would not, all my inventory is minimally leased for 90 days. That way I'm not sitting on nothing. Everything's turning.
That's guaranteed to make the wheel turn. That's true.
See, because I'm trying to sell that Uber driver the Range Rover. You follow me? I just want the production off of it. I'm gonna go get in bed, get the contract and the insurance. I just want the revenue that it produces. I want the contract. I want the equity. Equity can be insured. And if I'm on a lease, it's going to be in top-notch condition. Maintenance going to be on top of it. And if it breaks down, they're going to get me another one. We Gucci. Oh, we can get into a real interesting conversation if you guys are really picking up what I'm putting down.
I sure would like you to elaborate because I'm hearing you and I'm taking this further with more, rinse, wash, and repeat. But
right. Let's talk about it from there. Someone that has a 650 or better credit score, go on to Go Capital and get approved for equipment leasing. So I'm going to show you one vehicle, 10 vehicles. The first lease is going to be for your client who's already driving for Uber and Lyft to get him more trucks in his fleet. But you're going to be the facilitator. So you got a contract with this guy who's been Ubering or Lyfting for 6 months. And you're saying, all right, here's the deal. I'm going to charge you $600 a month. But what you get is a 2024 Range Rover. And after 18 months is yours. Listen, I said that. $600 a month, 18 months, the Range Rover is yours. What's 600 times 18? Who has a calculator? Who can multiply 600 times 18?
10,800.
All right. Now, because I'm leasing, I don't lose that 10 grand in that lease. It's just that now that the Range Rover has 10,000 vested in it and is worth 50 grand, it's now ready for the secondary market. So I'm going to sell this guy this $50,000 vehicle for really 10 grand. Why on earth would I do that? Because the 10 grand that I made off of him, I don't have to wait 18 months to get it. I just need him into a payment structure that he can afford. I need performing paper. See, when I write up the contract, every dollar that I've invested in insurance comes back in the form of credit. So this $50,000 Range Rover, I was able to, month after month, have that asset on the book. So 6 months before he came to me, he didn't have no claim. He wasn't in no wreck. He ain't killed nobody. He done been in my vehicle at least 90 days. He ain't hurt nobody, killed nobody at that point. I got $1 million policy on this thing that I can take 200 grand out of it. So I got no problem selling him this $50,000 Range Rover for 10 grand. I got 200 on the other side. I just need you to keep the contract moving, and I need you to what? Come back and buy more what? Trucks. I'm making all my money off the insurance, and he got a $50,000 vehicle for $600 a month, and he paid it off in 18 months. Win, win, win. Because my market ain't what he's paying me in fee. I have a whole different model. Now we're going to scale this up. I ain't relying upon what he's doing in his Uber business. I'm relying on that lease because I got a tractor trailer, a box truck, and a dump truck in that same lease. That's my money makers, those road haulers, not the Uber and Lyft. That's for him. I just use that to get in the door. Because I got the truck, the box truck, and the dump truck, they threw in the Range Rover. I'm going to say it slowly. When you approach this the way I'm explaining it, you're going to cause that dealership to go to work for you because they're trying to accommodate your contract. See, when you come in the door, you're getting a truck, you're getting a tractor trailer, you're getting a dump truck, and you're getting a box truck. So they're going to throw in the domestic vehicle. That's your step. Hey, I'm going to buy 3. I'm going to come in and I'm going to get a tractor trailer, I'm going to get a dump truck, and I'm going to get a box truck. All I ask is that you get me a BMW or a Mercedes or whatever. That's the step. Give me access to that while I'm in this lease, and we'll do this every month. What costs more? The tractor trailer, the box truck, and the dump truck, or the Range Rover and the Mercedes? What costs more?
The dump truck and the tractor trailer.
Right. Dump truck, tractor trailer, box truck. These are all 2023, 2024s. What costs more? That's why I come in and get $1 million policy. And I just add the car as a rider. That's why I'm able to leverage the insurance because it's a commercial lease. I just added the other VIN number to it.
Let me ask you a question.
Gotcha.
You got to speak up a little bit, Mark. You sound far away, big bro.
Okay. Can you hear me?
Yeah, a little bit better. That's a little bit better.
Okay. You were talking about the Maseratis and everything earlier.
Right.
And I know traveling the U.S., the bigger cities, they have like other private companies.
Right.
Rent out Maseratis and, the kind of the upper. Now,
right.
You do it for that, or you take the Maserati and do it under Uber and Lyft also?
What you would do is if you had access to 3 Maseratis, then you can easily get into an Uber and Lyft on a VIP petitions. Like, you only be listening to Uber and Lyft for VIP rides.
Okay.
That means you get the better rates because that's the rates I use. I use the VIP rates.
Okay. Now, one more question. Now, when you go on, I know you say it's for the broke people, but I just came off a vacation and I had rented some jet skis. Can you do the same thing?
Yes, same thing. I just want you to really think about the scale of it.
Yeah, right. Okay. Well, see, that's funny that you're having this conversation because I have a friend that wants to do it already.
Mm-hmm.
So, wow, that's crazy.
There you go. But this is the opportunity. So if you guys are really catching this, we want to use, before the end of this month drops out, 15th of July over the weekend. We're trying to get as many loans and various different things in before the 15th, so you'll make the next cycle with disbursement. And this is something that you can easily do going into July, August for the rest of the year, especially with anyone who's already in that business. They may be just Uber and lifting to make extra money, and you can offer them a franchise opportunity. Especially if you're the company that's facilitating the contract. That means they're just onboarding like truckers to your company. Then remember, every dealership that you pass, these vehicles are in trust. So some folks, you may have a whole scheme. You may want to have a certain type of vehicle that you want to use in this scenario. I just use Maseratis and Range Rovers and things of sorts to illustrate that. But there's all kind of niches that you can develop. I just happen to know some folks that can get $50,000 Maseratis for 19 grand. That's all. They're worth 50. They're only paying 19 for them. And we can talk about that off off out of class.
Yeah.
But I'm gonna give you the approach one more time so you get it. When you offer this opportunity, you want to do large trucks and trailers. You want to do dump trucks, and you want to do box trucks. That way, when the domestic vehicle is thrown in, it's part of the equity deal. That's like the incentive. Because see, if you have on your lease that that large truck with minimal miles, the dump truck with minimal miles, those type of equipment, they make money as long as the wheels are turning and somebody in behind the seat. Now it's just a matter of you got a brand new vehicle. You just needing a driver that wants to put it into a lane or a contract. See, it's the trucks that are paying for the domestic vehicle that the Uber driver is using. And you need the Uber driver to think about expanding his fleet. Why? Because you want him to come in and buy a truck from you. You follow me? The same thing you're doing, you want to turn right around and sell him on the same idea. All this can be done through insurance and a 600 score. Any questions? Any questions? If there isn't any questions, who would need that outline that I just showed you in Chat GPT?
I would.
Okay. That sounds like Jarvis. Who else would need it?
Mark.
Okay, Mark. Um, Anyone else who need it, press 9 on your keypad, and I can definitely make sure you get a copy of it. Trying to look and see how many folks I got on there. That's definitely putting it out there. Well, I know I've given you a lot of information to think about. I've given you guys a lot of information to think about. So here's what I want you to do. I gave you guys a homework assignment to do last night. I ain't going to put nobody on the spot. What I am going to say is this. Before I jump off of here, who needs a quick walkthrough on what type of Chat GPT setup they can use right now to really get into this intel?
Mark.
Who needs a quick tutorial walkthrough on what you can set up? right now?
I do.
Okay. So I'm going to take the person who said they do as an opportunity to show the whole class once again the setup. Let me mute everybody. And now I'm going to give you what you can, and I want you to start, the more you use this stuff, the easier it'll be to really kind of see out this stuff from a high-end perspective. So again, I don't know if my screen is still sharing. Let's see. Let me stop the share. And I'm going to come back to the share. Okay. All right. All right. Now you're seeing my whole screen. You're seeing my screen now. I'm going to go to, and this is the Legal Jacks website. For those of you that haven't been in the new website, this is what it's looking like. So we got the ticker symbols up. It's tracking stocks and all that good stuff. I'm using Firefox. So in Firefox, what I would want you to do is go into your icon down here. You're going to see where it says add-ons and themes. Toggle on that. And when you go to add-ons and themes, these that I've activated are going to be the ones that I want you to really use to really get the effect that I'm talking about. You got one here that's called Chat GPT Rarity. It's this one here that you're looking at. And there's also going to be one down here at the bottom that's called YouTube Digest Summarizes. If you simply activate these two, now of course I got more than those two on mine, but to give you the effect of being able to go through the videos, especially the classes that we do, because the information in the classes, these things have the ability to summarize them and repetition them. But you want to do the YouTube Digest and also this particular add-on, and also go ahead, if you hadn't already done so, and go into Chat GPT and go ahead and at least establish an account in the free account section. It works better when you got the paid version, but at least to get you started, you're able to do, some good things. I'm just going to show you this. Now, I'm going to show you what Chat GPT has already done to the class we did yesterday. So this is why I am telling you want to go ahead and do this. I'm going to go to my YouTube because I put yesterday's class inside of my YouTube page. We'll give it a chance to definitely petition over here. Let it do what it's doing. I'm going to close some of these windows here. Close that one. Close this one. And close that one. It's taking a little while here. It's only because I'm sharing the screen. So let me just stop the share. So it'll go ahead and catch up here. There we go. All right. Now it's going through. See if I can bring the class back up. All right. And yes, we will be having, I think, there's going to be a live session tonight inside of Trustee Training. So definitely get prepared for caster.fm. I will be putting a link inside both the Bitrix spaces because you're going to have a lot of explosive information that's going to be coming down the pipeline by way of WTDTAradio.caster. All right. You're going to let's go to history. So you can kind of see what it's doing. And this is the class we did, yeah. CLC to CO. Now this right here is what it's doing already with just this course right here. All right, now I'm going to bring up my share again so you can see it. All right. Okay. Now, this right here was the class we did yesterday. See how it's already summarized it? You guys remember what we discussed in class yesterday, but this is what the AI has already done with that particular class. It's already got it broken down into understanding the financial corrections, commercial actions. Now you think that's something. This is the actual, what it transcribed and rewrote. And just in case I wanted a rendition of this, but I didn't have time to read it, but I didn't want to have to go through a whole hour and 12 minutes, let me show you what else it did. I got to stop the share to show you this. And these are all from these plugins that I'm telling you. So not only did it transcribe it through the YouTube, it also created a whole nother podcast. Let me show you. Let's see here. Go here. And the reason why I'm showing you this is because the more you study the content and you see it from different perspectives, you'll learn different things from it. And basically, I've trained the AI to start, segregating the asymmetric information. But let's see. I'm going to go back here. I think I can show it to you right here. Yeah. Go here. And this right here is going to be the, let's see. Now I'm going to show you what it did. This is the actual podcast that it created. Check this out.
Understanding the commercial game, navigating the dynamics of creditors and debtors. Introduction. This article explores the intricate dynamics of the commercial game, where players assume the roles of creditors and debtors. By understanding the underlying principles of this game, individuals can navigate the complexities of the financial landscape with greater clarity and purpose. Trusteeship, a key element in prisons and society. Trusteeship is a concept deeply ingrained in both literal prisons and the broader societal context. Understanding the significance of trusteeship can shed light on the privileges and responsibilities it entails. Key points to consider include privileges of trustees. In prison, trustees are granted certain privileges, allowing them to move and shape their environment. This concept extends beyond prisons, with society often training individuals in trusteeship without their realization.
Now, I'm just going to stop it right there, but that was from the conversation when we got into about how inside of a physical prison there's trustees, so you should actually understand trusteeship being used exterior. Now, it took our entire dialogue and it created a whole rendition. So it's imperative that you start using these tools because remember, if you listen long enough, you'll learn something. Look, I appreciate everybody's time and energy. If you got any other questions, comments, or concerns, please get at me. I'm going to be in the office till about 7 p.m. You can reach me inside the Bitrick space. You can give me a call at the office at 407-792-2774. Do not forget to remind me that you need the particular documents that we just expressed in class. You can simply send me a text or reach out and send me a message, so that way you'll get it. And probably in the next maybe 30 minutes, if you are available, definitely want to tune in to WTDTAradio.caster.fm for more exclusive content. With that, I'm going to say peace and love, family. Peace and love.